So now we're going to look at a very highly contentious and yet very sensitive part of family law, and that's child custody. So when the parents separate or divorce, the court's main concern is supposed to be the well being of the child. So that's what we're going to talk about. So to begin, it is important to understand that there are distinct legal components that make up a custody arrangement. So we don't talk about custody as just a single thing. It is generally divided into two main types. The first is physical custody. So this refers to the right of an adult to have a child reside with that adult. So it's commonly referred to also as residential custody. So it is essentially where the child is going to primarily live. So, for example, if a divorce decree states that the mother shall have sole physical custody, it means that the child will live primarily with the mother. She is the custodial parent. And then the other parent would be the non custodial parent. Okay. And this determines the child's primary home, their school district, and their daily care provider. The other is legal custody, and this is defined as the right to make the major child rearing decisions on healthcare, education, religion, discipline, general welfare, extracurriculars, things like that. This is also known as the decision making responsibility. So, legal custody is going to determine who has the authority to make significant choices about the child's upbringing. So, for example, even if a child lives primarily with one parent who has the physical custody, both parents might share joint legal custody. So this means that they must consult and agree on decisions like which school the child attends, whether the child receives any kind of major medical treatment, like what religious services the child can be taken to, things like that. So these two types of custody can be awarded to one parent exclusively, or they can be shared. Now, I already mentioned the existence of joint legal custody, but joint physical custody refers to the right of both parents to have the child reside with them for alternating, not necessarily equal periods of time. It's also called shared physical custody, and that means that the child spends significant time with both parents, but again, though not necessarily a 50-50 split. But the intent is to maximize each parent's regular involvement in the child's daily life. So, for example, if parent A and parent B have joint physical custody, then their child might live with parent A for say 4 days of the week, and then parent B 3 days of the week, or they might alternate weeks, 1 week on, 1 week off. But the arrangement focuses on that shared residential time and the daily care rather than just decision making. So the goal is to ensure that both parents have substantial hands-on time with the child. Okay. And it's common for courts to award joint legal custody, even if physical custody is primarily with one parent. And that's because it encourages co parenting and shared responsibility for those major decisions. It is not as easy to get the joint physical custody. Now, before we get into contested custody, let's briefly kind of revisit a separation agreement, which we talked about before. And this is the contract between separating or divorcing parents, and is often the preferred method for resolving these child custody issues. It allows the parents to kind of pull together a solution that is tailored to their family's unique needs rather than having the judge just go, here, this is what you're getting. Okay. So a separation agreement can detail things like the physical custody schedule, like what specific days and times the child spends with each parent, including, regular weekdays, weekends, holidays, summer vacations, all of that. Again, that legal custody decision making. How are these major decisions being made? Is it jointly? Is somebody going to have final say? If there is a dispute, how is that dispute going to be broken? It'll lay out things like communication protocols, like how will the parents communicate about the child? Is it going to be through a co-parenting app, through email only? Is it phone calls only? How frequently is that going to happen? And then financial responsibilities, because beyond the child support calculations, there's going to be things that are going to come up like the out-of-pocket medical expenses or extracurricular activities and things like that. So while parents can agree to anything they want in the separation agreement, though, it is important to remember that the custody provisions in a separation agreement are still going to be subject to the court's review. So the court is going to ensure that the agreed upon terms are, in fact, in the best interest of the child before incorporating them into the final decree. The judge is going to act as kind of the ultimate guardian of the child's welfare. Now, when making custody decisions or even approving, the parenting plans, the courts operate under the certain guidelines for parents, emphasizing the ongoing responsibilities that exist even after separation. So, this overarching principle, as we've already stated, is always in the best. It's the best interest of the child principle. So, courts typically expect parents to do things like cooperate and communicate, even if they don't get along. Parents are expected to put their differences aside to facilitate co-parenting. They're expected to prioritize the child's needs. So they have to place the child's emotional and physical and developmental needs above their own desires or animosity towards the other parent. They are to foster a positive relationship with the other parent. So they're to encourage the child to have a healthy relationship with the non-custodial parent, unless there's a safety concern. They are to maintain stability. So they're to minimize disruptions for the child's life, like school routines, extracurriculars, friendships, things like that. They are to provide adequate support. So both parents are supposed to financially and emotionally support the child. And courts often provide templates or, refer parents to educational programs that kind of highlight these expectations, underscoring that co-parenting is an ongoing responsibility that requires maturity and flexibility from both adults. In Georgia, if you are getting divorced or separated with children, you will be expected to go through the divorce parenting seminar for this particular reason right here. So while many custody disputes are resolved through the parenting plans where they agree on it, sometimes parents simply cannot agree. And so when this happens, it becomes a contested custody matter, meaning that the court has to intervene and make the decisions. So this is where litigation becomes necessary and the judge has to apply the best interest standards for the child. So, these are often the most emotionally draining, time consuming, and very expensive parts of a divorce. And they involve extensive investigations, can involve expert testimony, but they will definitely usually have some very deeply personal things that get revealed. And the court's role is to step into the parent's shoes and determine what living arrangement and decision making structure will provide the best optimal environment for the child's overall well being. Now, in a majority of contested custody matters, the dispute is a parent versus parent conflict. So the court's primary duty is to apply that best interest standard. So this is a standard that's used by the court to decide what would serve a child's welfare when a court has to make custody or visitation or adoption or guardianship or change of name decisions. This is not about what is fair to the parents or what the parents even want. It's solely about the child. So the best interest standard is flexible and it allows the court kind of broad discretion to consider a wide range of factors that are unique to each family, okay? So there's no single formula or checklist that applies universally, but rather kind of this holistic assessment of the child's specific needs and circumstances. Now, let's talk about the parenting plan. So the feasibility and the proposed details of each parent's parenting plan is pulled together. Okay. And this is a child custody plan that for separated parents covering living arrangements, decision making, finances, communication, all of those things. When we submit in Georgia and it's a contested matter, we submit a proposed parenting plan. And courts will evaluate how each parent proposes to meet the child's needs and manage the daily routines and even to facilitate contact with the other parent. Courts are going to strongly favor stability for the child. And this includes maintaining continuity in the child's home, their school, their communities, and even in their relationships. So frequent changes or disruptions are going to generally be seen as detrimental to a child's well-being. They will look at the attitude on visitation by the other parent. So there has to be a willingness of each parent to foster a positive relationship between the child and the other parent. It is absolutely crucial. And again, this is withstanding any kind of abuse, okay? But attitude on visitation by the other parent is going to refer to how cooperative and encouraging each parent is going to be in facilitating the child's contact with the non custodial parent. Because a parent who attempts to alienate the child from the other parent is generally viewed unfavorably. Now, I know your book doesn't say this, but in Georgia, we call it the parent who is the most willing to facilitate a meaningful relationship between the child and the other parent. The court will look at the availability for the child's needs. So, the capacity of each parent to physically and emotionally be present for the child is going to be looked at. And that includes their work schedules, their support networks, and even their willingness to participate in the child's activities. They'll look at the emotional ties, and the strength of the emotional ties between the child and each parent will be examined, and then the child and any other siblings or other significant family members. Now, courts are increasingly aware of parental alienation syndrome, though I will say it is a controversial concept and it's not recognized as a clinical diagnosis in all psychological circles, but it refers to a child's unjustifiable estrangement from one parent due to the manipulative influence of the other parent. So courts will actively discourage and penalize such behavior if it is proven to them. They look at the career choice of the parents and how a career choice of a parent might impact their availability for the needs of the child or the stability for the child. Like, is there extensive travel? Is there demanding hours? And these initial factors are going to give us a sense of the holistic nature of the child's best interest. They'll even consider wealth. The wealth or the financial resources of each parent is a factor, but it's not determinative. So a parent shouldn't try to buy custody. Okay. The court is going to look at whether the parent can provide a stable and adequate environment, not who can provide the most luxurious one. They'll look at legal preferences. Courts once relied on certain legal preferences, I should say, that are now largely discredited due to being gender based. And those included things like the tender years doctrine. And that was a presumption that young children, typically under the age of 7, sometimes 10, should be placed with the mother. There was also a primary caregiver presumption that said that that custody should be awarded to the parent who has historically performed the majority of the child's caretaking task. So while not gender neutral, it sometimes still a factor that gets considered. And then the whole older boys do better when placed with their fathers. This was discredited based on traditional gender roles. And these presumptions are discredited because they are more gender based as defined or as applied. Now, modern courts strive for a gender neutral custody decision. So a less controversial presumption would be that siblings should be placed together, to maintain those family bonds, unless there is a reason to separate them. Morality and lifestyle. The morality and the lifestyle of a parent, it can be considered, but under the Nexus test, is the only way it can be considered. So this test asks, do the parents' morality, sexuality, and lifestyle adversely affect the child? The court won't judge a parent's private life unless it directly harms the child, right? So a parent's, in an unconventional relationship or their sexual orientation generally won't be a factor unless it can be proven that it is a direct harm to the child's welfare, like maybe exposing the child to dangerous situations or creating an unstable environment. The mere fact of a different lifestyle is not enough. Domestic violence is a huge factor, and most states have statutes that create a presumption against awarding custody to a perpetrator of domestic violence, or at least require specialized arrangements to ensure the child's safety and the non-abusive parent's well-being. Religion, this can be a factor, but courts cannot prefer one religion over another. The relevant question here again is going to go to that nexus test. Can can they consider any effect the practice of a particular religion will have on the child? Like, can a court they can't deny custody to a parent simply because they're Buddhist and the other parent is Christian, right? But if one parent practices a an extreme religion, okay, that might involve like denying a child necessary medical care, like blood transfusions for a serious illness, then the court can intervene to protect the child's health, and they would use the nexus test in order to do that. Race, oddly enough, this can be considered, but it cannot be the sole factor that determines custody. So courts generally avoid making custody decisions based on race because, again, it would violate the equal protection principles. Wishes of the child. These are usually considered, especially for older children. Here in Georgia, we have the ability to have a child file an affidavit of election if they are of a certain age. But again, it is usually for older, more mature children, and it gives weight to the child's preferences, and that weight even increases with their age and the maturity. So the judge can interview the child privately or even appoint a guardian ad litem to represent the child's best interest. Expert witnesses, these can be very influential, like child psychologists, social workers, forensic evaluators. These are often called upon during contested custody matters to provide assessments of the child's needs, the parental capabilities, and the recommendations for the court. And the this list that I've just kind of gone through, it demonstrates kind of like the what the court's going to use in trying to determine whether or not who they're going to place the child with, and it's should show hopefully that there is an individualized nature when it comes to the best interest of a child determination. It is not a one size fits all. Now, visitation. When one parent is awarded physical custody, the other parent is typically granted visitation, which is increasingly referred to as parenting time. And it's to emphasize the importance of that parent's role. So, in general, courts favor liberal visitation time for the non custodial parent. The underlying belief is that the child's best interest is to have a continuing, meaningful relationship with both parents, absent, of course, any kind of compelling reason to not. And standard visitation schedules typically include alternating weekends, alternating holidays, and then extended time during summer breaks. Now, the specifics are often tailored to the family's unique circumstances, including like child's age and the geographic distance. Okay. Now, supervised visitation is going to be an option if there is danger of violence of removal, or danger of violence rather, or the removal of the child from the jurisdiction. Now, if there are credible concerns about a parent's ability to safely care for the child, or if there is a risk of abduction, then the court can order that visitation to occur only under the supervision of another adult, which would be like a family member or a professional supervisor, and it has to be done in a controlled environment. So, for example, if a non custodial parent has, say, a history of substance abuse or domestic violence, then a court can order that all of their parenting time occur at a like designated visitation center or in the presence of a trusted family member. Now, one of the most contentious areas in child custody is relocation, which is also called like the move away case. And this arises when a custodial parent wants to move a significant distance with the child, which would substantially impact the non custodial parent's visitation rights. Now, on one hand, custodial parents have a right to travel, okay? This is a constitutional right to the freedom of movement. However, this is balanced against the child's best interest and the other parent's rights. The general rule is that when balanced against the best interests of the child, a court can refuse to allow the custodial parent to move significant distances with the child, and it's usually over 50 miles, if the move substantially interferes with the visitation rights of the non custodial parent. Now, many states have specific statutes or judicial tests when it comes to relocation cases, and it's often requiring the moving parent to show that the move is in the best interest of the child. And they would consider factors like the reason for the move. Is there a better job? Is there better family support? They would look at the ties to the current community, the impact on the child's relationship with the non custodial parent, and even the ability to maintain meaningful visitation despite the difference. So, for example, a mother who has primary physical custody might receive a job offer that requires her to move 500 miles away. And the other parent can object, arguing that such a move would severely limit their ability to see their child every other weekend. So the court would hold a hearing weighing the mother's reasons for the move against the impact on the child's relationship with the other parent. And they would decide whether or not the relocation is in the best interest of the child. So if the move is denied, the mother might have to choose between the job and then remaining near her child. I can tell you that one thing a lot of people will do is they will try to move beforehand. So they try that whole ask for forgiveness instead of permission, and that will backfire because the court will definitely have you brought back to the state. Now, custody and visitation rights are primarily for parents, but third-party visitation has emerged as an area of legal debate, particularly concerning grandparents and other relatives. So visitation rights can be given to other individuals other than biological parents, if doing so does not interfere with the constitutional right of a fit custodial parent to make child rearing decisions. And the landmark case that defined this is Troxel v. Granville. And in this case, the Supreme Court addressed a state law that allowed a third party to petition for visitation rights based solely on the child's best interest. And the court found this law unconstitutional as applied. Okay. And actually, we'll dig into it. I decided to create a slide for it instead, just so I can kind of dig into it a little bit better. And that's because this case is a big one. It fundamentally shaped the landscape of who can seek and obtain visitation with a child, especially if there's a biological parent that objects. Now, this case involved the paternal grandparents of two kids, and the girl's father had committed suicide, and that was the Troxel's son. And before his death, he had regularly brought his daughters to visit his parents. And after his death, the grandparents continued to seek visitation with the children. Now, the girl's mom was Tommy Granville, and she initially allowed some visitation, but she later stopped it. And the Troxels filed a lawsuit in state court seeking expanded visitation rights under the state statute. This statute was exceptionally broad because it allowed any person to petition the court for visitation rights at any time, and it permitted the judge to grant such visitation when it was seen as in the best interest of the child. So the issue before the court was, does the state statute, which allows any third party to petition for visitation rights based solely on the best interest of the child, infringe upon the fundamental constitutional right of a parent to make decisions concerning the child, their custody, and the control of their children as protected by the 14th Amendment's Due Process Clause? And the court had a 6-3 decision. There was no single majority opinion in this. They did have a plurality opinion that was by Justice O'Connor and 3 others. But they held that the statute as it was applied to the facts of this case was unconstitutional. So the statute infringed upon that fundamental parental right to make those decisions and to control in the care, custody, and control of their children. Now, the plurality emphasized that the child rearing decisions of parents are presumed to be correct, okay? And Justice O'Connor, in this plurality opinion, wrote that they stressed the fundamental parental right of fit parents to make decisions regarding the upbringing of their children, okay? This right is rooted in the Due Process Clause of the 14th Amendment, and it's considered one of the oldest and the most fundamental liberty interest, okay? The court found that the statute was unconstitutionally broad because it allowed any third party to override a fit custodial parent's decision about who may visit their children, based solely on the judge's determination of a child's best interest. And the state failed to give any special weight to the fit custodial parent's decision or to require any kind of showing of harm to the child if the visitation was denied. Now, the plurality reasoned that simply allowing a judge to substitute their own best interest judgment for that of a fit parent without any kind of heightened standard or any kind of deference to the parent's decision unconstitutionally infringed upon the parent's fundamental liberty. All right. So, this presumption is that a fit parent acts in the best interest of their child. So, to overcome this presumption, a third party had to typically demonstrate more than just that. That visitation would be good for the child. Okay. They had to show that denying the visitation would cause the child harm, or that the parent is somehow unfit before a court could intervene in such a fundamental parental decision. Okay, now the Troxel case, it doesn't entirely rule out third-party visitation statutes, but instead it indicates that these statutes have to be narrowly tailored, and it has to include safeguards to protect the fundamental rights of fit parents. And that means that future statutes would need to give deference to those parental decisions, or they have to require a showing of parental unfitness or specific harm to the child if visitation is not granted. Okay. So this decision, it affirmed that constitutional right of that fit parent, again, to have that ability to do all the decisions with their children, including whom their children associate with. And it established a strong presumption in favor of a fit parent's child rearing decisions. But again, state statutes could allow for third-party visitation, but had to be carefully drafted to avoid infringing on that fundamental right. Now, the concept of shared custody and co-parenting extends beyond traditional marital relationships, reflecting the diversity of family structures that exist today. So a parent can voluntarily enter an agreement with a non-parent that allows the non-parent some measure of custody of the parent's child. And this arrangement is also called co-parenting, which is the shared responsibility by two adults to raise a child, regardless of marital status or sexual orientation of the adults. Now, this is particularly relevant for things like de facto parents or psychological parents, and we're going to discuss that. But it's an adult who has acted as a parent figure who might be able to enter into such an agreement. You have same-sex partners, before marriage equality, and even after. If one parent is the biological or the adoptive parent, they might formalize the other partner's co-parenting role through an agreement. And then you have blended families where you have a step parent who might have taken on a very significant parental role, and they might enter into a co-parenting agreement with the biological parent. But it's important to note the dual meaning of co-parenting, because while it refers to agreements with non-parents, co-parenting also refers to communication and cooperation by separate parents on the raising of their children. So it's a broader definition that applies to divorced parents, or separated parents who are the biological parents who strive to work together for the benefit of their children, even if they no longer share a household. For example, you might have a same-sex couple, person A, person B, and they separate. Okay, so person A might be the biological mother, all right? And they might enter into a co-parenting agreement with person B, who's the non-biological mother, in order to formalize that ongoing role in raising, the child. And this agreement would outline visitation rights, decision-making authority, financial contributions, all of those things, just basically recognizing her as a co-parent despite not being a biological or an adoptive parent in the traditional sense.